Hi, this is Cora Stack here. I've been thinking about this for months and months and trying to refine it and condense it. So I think I have a definition that I'm happy with now. I want to really define a constitutional blind spot in a way that an ordinary person or a student would understand it. That's how I've operated all my life. I'm always interested in trying to obtain excellence or strive for excellence in what I do. So, constitutional blind spots, and this, believe me, is no easy task in this case. So, constitutional blind spots: how time can defeat effective constitutional review. So, a constitutional blind spot arises where a constitutional problem exists, but no realistic opportunity is provided or made available to a person seeking constitutional review to have that problem examined and, where necessary, corrected before the relevant democratic event or constitutional process becomes final. So I won't tell you how long it took me to get that right. So if it therefore creates a constitutional gap between the formal availability of review and the practical availability of effective constitutional correction in time, this is hugely significant for constitutional law because it's there to protect citizens in these kind of crises. And then this happens. This distinction is essential. A constitutional system may formally provide courts, procedures, and remedies, but if those mechanisms cannot operate effectively before before the event that matters becomes irreversible or constitutionally final, the existence of review on paper may be very different from meaningful constitutional protection in practice. So it's a failure of constitutional law. It's a gap in constitutional law, or a failure, if you wanted to be very strong about it, but we'll call it a gap. So, for example, elections provide a particularly clear example. Well, this is how it arose. It developed in my mind as a result of what examining sequences of the way my case was handled in the High Court, through a series of hearings and the determination on each hearing, and looking at that backwards, from the day before the election where the judgment was reserved unto that day. So where it went against me, and at that point it was not possible to have what I called meaningful review. So elections provide a particularly clear example. So a constitutional challenge, allegedly, a constitutional challenge may begin while there is still sufficient time for a problem to be examined and, if necessary, corrected before polling day. For example, I entered the court, very, very as soon as I could after the nominations closed in the presidential election. There was a really tight period of time in which I could actually go to the court and after the nomination and make an application for a challenge that the nomination process was defective. So that was the and there was other issues as well that I brought into that judicial review. And it was the first judicial review I ever did, and I had done 80 edits, or 80, a huge amount of edits on that. So it was a very intense piece of work over a very short time. So extraordinarily difficult piece of work for a first timer in the constitutional review business. So, but constitutional time can then be consumed through a sequence such as constitutional challenge, preliminary procedural issue, jurisdiction or justiciability question, procedural substitution or sequencing like this, procedural reframing, further submissions or adjournment, institutional caution, judicial restraint, deference to the established political parties, process for the passage of time. So all of these kind of things can come into letting time pass. Even there's a very narrow period of time, but all of these sequence of decisions or doctrines or procedures can go from one to the other, and the time passes. None of these developments necessarily removes the court's formal constitutional power, nor does their occurrence necessarily establish deliberate delay, but their cumulative effect may be constitutionally significant. While the legal process is dealing with doctrine, procedure, and institutional concerns, the democratic process continues, at a much faster speed. So nominations close, candidates are confirmed, ballots are finalised, campaigning takes place, polling day approaches. The closer polling day becomes, the more, as you can imagine, the more consequential intervention may appear. So what would a judge do the day before the election if the judgment was adjourned until that day? So what would he do, in the High Court, or what has he done in the past? So what would if you were to talk about the balance of convenience, what would he decide to do? So, which I did. It was mentioned several times. Brilliant concept and all. So, a constitutional problem that might have been capable of relatively straightforward correction weeks earlier may therefore present a court with a much more difficult institutional decision immediately before a national election. I mean, the disruption would be, would be absolutely terrible. So the court may still have the legal power to intervene, but caution may become greater precisely because the matter was not resolved earlier, using all these other, moved along. So the polling day arrives. If constitutional finality attaches to the electoral outcome, the remedy that mattered before polling day may no longer be realistically available. Well, it is still available, but it's the difficulties in siding with the applicant become hugely greater than they might have been earlier. The sequence can become, therefore, constitutional problem identified with an application. Then there's procedure, reframing, caution, deference, delay, approaching finality, greater reluctance to intervene, election, finality. This is why constitutional time is not neutral. The political process does not have to acquire any new formal legal power, and the court does not necessarily lose any former constitutional power. Yet the passage of time can make the political position already created progressively more secure, while making meaningful constitutional correction progressively more difficult. It's brilliant, isn't it, how it's done, how it can be done. Delay can therefore redistribute practical constitutional power. The concept has since expanded beyond elections in my work. What began as an examination of constitutional timing has developed into a much wider research framework. The same underlying question appears in other areas of my work: protective disclosures and acts of omission. The problem may be an express refusal to act. Accountability can also be weakened through failures to investigate, preserve evidence, interview witnesses, disclose conflicts, correct inaccurate information, or respond effectively to reported wrongdoing. This led to the development of the idea of the protective disclosures blind spot and wider works on acts of omission. It's a really difficult concept, acts of omission, but it's clear to me now. Failure to act. If we just focus on that, that's kind of central to an act of omission. It's very hidden. It's a very covert kind of a concept. Again, the distinction is between protection existing formally and protection operating effectively in practice. Access to justice. The framework also has been extended into my work: access to justice, legal aid, and the constitutional blind spot. A person may formally possess constitutional legal rights, but those rights become very different in practical terms when there is no realistic access to representation, affordable procedures, timely adjudication, or an effective remedy. A right that cannot realistically be vindicated can become a right principally on paper. Procedural reframing. Another strand of the research examined what happens when the substance of an original constitutional problem is gradually displaced by procedural questions hidden from view. So it's you go in with your application and your arguments, and the whole thing is all twisted around, and the constitutional problem becomes invisible in the judgment. So the legal system, well, this can happen. It's known as one of the main tactics used to shut down, and it's shocking, really. We've got a kind of a shock. you'd be the target of this kind of tactic. It's really shocking because to me it's like gaslighting. The legal system, it's a right stab. If you're a logician and you're hit with this twisted narrative, the legal system may remain extremely active while the underlying constitution, which, I mean, this is real life. This affects real people. So this is not a joke. If somebody gaslights you or you're gaslighted by a procedural reframed case, it's extremely serious. So, I mean, this is only one in a sequence, but to me, this was especially given that the judgment was reserved, and even that was highly questionable. So, the legal system may remain extremely active while the underlying constitutional question receives progressively less direct examination. Procedure can therefore become part of the mechanism through which a blind spot develops. Separation of powers and democratic accountability. The concept was also developed into work examining whether repeated procedure, institutional and temporal failures can gradually weaken the practical operation of the separation of powers. I mean, and this is what I think happened in the presidential election. The separation of powers failed, really, essentially, up to now. No dramatic constitutional rupture is required. Instead, many individual defensible decisions may accumulate. Over time, the cumulative result may favour institutional continuity and the established position over effective constitutional correction. I mean, this is my position. This is where the idea connects with constitutional drift and democratic decline. Artificial intelligence and governance. More recently, I've extended the framework into AI governance. I've put a couple of videos there from very senior people about the risks, and it's shocking. And I mean, anyone in Ireland that doesn't, I think they should listen to that video. It's on my last YouTube, and really understand what the future looks like without regulation. And I have my own theory that we should have a sort of a network of like traffic lights. So if we could kind of look at the theory of if we look at the traffic light networks in Ireland and impose that on AI, we might get some. It's every turn, every twist, every turn in the road, every juncture. There's a traffic light, red, amber, and green. So this is my vision for AI regulation. It has to be that tight. If it's going to be properly regulated, and looking at the EU Act, it's too loose. It's way too loose, but it's a start. So artificial intelligence and governance. More recently, I've extended the framework into AI governance. AI creates another version of the same fundamental problem. Technological systems may develop and become embedded extraordinarily quickly, while law, constitutional scrutiny, democratic oversight, and institutional accountability move much more slowly. It's like Einstein's theory of relativity. Well, I wouldn't put myself into his league, but still, it's interesting. It's interesting that this has arisen as a result of my analysis here, my time spent working on this problem. By the time effective scrutiny occurs, systems, infrastructure, and decision-making practices may already be deeply established. This raises a familiar question: what happens when formal mechanisms of accountability exist, but they cannot operate effectively before technological decisions become practically entrenched? I mean, this is a hugely important question currently. This is another potential blind spot. A broader research framework is therefore emerging. A constitutional blind spot is no longer simply an argument about election litigation. It has become a way the distance between formal rights and practical remedies, formal accountability and effective accountability, legal power and unusable power, procedure and substantive justice, constitutional review and constitutional correction, and democratic authority and institutional finality. Across elections, protective disclosures, access to justice, institutional omissions, and artificial intelligence, the underlying problem is remarkably similar. A system can appear to possess all the necessary safeguards. Courts exist, rights exist, procedures exist, regulators exist, accountability mechanisms exist, but the deeper question is, can they operate effectively at the point when they are actually needed or required? If the answer is no, the problem may not simply be delay or administrative failure. It may reveal a structural blind spot. This is the wider significance of this research. Constitutional time is not neutral. and where review or accountability exists formally, but effective correction becomes unavailable before finality or entrenchment, the existence of the safeguard itself may conceal the weakness of the protection it is supposed to provide. So I was one of the the victims of the constitutional blind spot, and I'm only one of how many people that have ended up in this position in how many situations. So that's why this is why I think this is an extremely important developing concept in constitutional law.